So where do I even go to apply for a trademark?
To a lawyer.
If I was going to do it on my own, where would I go?
Don't recommend.
Okay, so you could go.
USPTO.gov, USPTO.gov,
Thank
United
you.
States Patent and Trademark Office, but highly do not recommend because guess what? Once you go and file that trademark by yourself, Jordan, if something is wrong, not because anyone's slow, stupid, unintelligent, ignorant, whatever, because trademark law is very tedious. There's a lot of caveats, there's a lot of requirements, there's a lot of specifications. If you don't do one thing right, then the trademark office is going to send you an office action. Basically, what that means is they're going to send you a long PDF of everything you did wrong or everything that they need from you to proceed. At that point, people want to look for an attorney. Well, guess what? Most attorneys don't want to take your trademark because at that point, they may not be able to fix it. Well, 9 times out of 10, a trademark attorney and intellectual property attorney will want you to start at the beginning with them filing your application because sometimes if you filed the application on your own or a different person filed the application, sometimes it's not fixable. And even if it is, it's going to take us a lot to untangle the mess or get around certain things or rectify the situation. And at that point, you're probably paying an hourly rate as opposed to the flat fee up front. When I say I charge X amount, that's for me to be on for the rest of your life. Well, the life of your trademark. That's one flat fee for the rest of your life. So you're looking at it like, oh, 1850. No, that's for the rest of your life. Unless you get late fees, unless you have to do renewals. Of course, there's extra fees that come into play. But for the negotiation, the legal research, the responses corresponding with the trademark office, I promise you don't want to do that. I promise you don't.
So, so your price is not indicative of just filing and putting it in the system. It's also to track and make sure if there is an office action or a letter or some sort of addendum or legal documentation thereof asking you to provide more information herein to what might be needed of your client. You're saying your 1850 covers all that, correct?
Exactly. There are like once we have a consultation, I send my clients an email explaining what this fee covers, what it doesn't cover, and then also attach the classes, attach all the information that's needed. It is like a collaborative process to get all the way to the application filing. Once the application is completed, you won't hear from me or the trademark office for anywhere from 9 months to a year. But when you do, the goal is for the first time the trademark office looks at it for it to be approved. But that's why the collaboration up front is so important because we need to gather all these details. We need to be on the same page. We need to work together to make sure your application is ironclad. Because if you're waiting 9 to 12 months, you don't want an office action back because then that's going to take another 6 to 9 plus months to hear back on that office action. And then it just goes from there. So that's why I fully, fully, fully recommend on these sorts of things having an attorney from the beginning because it takes so long. You don't want to waste time.
Now, what's the difference between a trademark and a registered trademark?
So good question. And that goes into the symbols. Like if you see the little TM next to something, you can put that TM as soon as you file the application. That means trademark, obviously. And technically, there is a difference between goods and services. So technically, anything that's a service, like a legal service or something like that, it should be SM instead of TM. And there is an SM symbol, but nobody ever uses it. But TM is technically for goods, like clothing, shoes, etc. But once you are fully registered, the applications process, they have no more questions. Excuse me, you get published in the Trademark Gazette. Nobody objects, and you're finally registered as a trademark. Then you move from the TM symbol to the R with the circle, and that means your trademark is registered. And then every certain increment of years, you have to renew your trademark and tell the office that you're still using this trademark. And if you don't, then it goes back out into the being available for the public to use.
Now, what if I have a product and I want to patent it and I'm not ready, but I still need to put it out? I can put out maybe like a provisional patent for maybe a year and then apply for an actual patent. Is that correct?
So